Hello, Tim.
Hello.
All right, we're going to go on the record in Bonneville County case CR 2020-1153, State of Idaho versus Timothy Kim Stillman. Mr. Stillman is present, appearing at the Bonneville County Jail. Mr. Stillman, for the record, can you hear me okay, sir?
Yes, Your Honor, I can.
All right, thank you. Your counsel, Mr. Gus Davis, is also present, appearing by video. Mr. Gus Davis, can you hear me as well as your client?
Yes, Your Honor, I can hear you both.
The State of Idaho is present, represented by Mr. Muir. Mr. Muir, can you hear me as well as the other participants?
I can, Your Honor.
We're holding this meeting by Zoom. There's also been a request to play this on YouTube. And it's been, we are live on YouTube, so that if people wanted to appear, they can, or watch the proceedings, they may. We're here today for a scheduled sentencing. So the parties ready to proceed, Mr. Gus Davis?
Yes, Your Honor.
Mr. Muir?
Yes, Your Honor.
All right, Mr. Stillman, let me review the history of this case. At the time of your arraignment on April 8th, 2020, you were informed that information had been filed against you by the State of Idaho, charging you with the crimes of 6 counts of possessing child exploitive material. You pled not guilty on that date. However, on August 15th, 2020, you again appeared in court with your attorney, and pursuant to a plea agreement with your previous plea of not guilty, entered a plea of guilty as charged to counts 1, 2, and 3. The state agreed as part of that plea agreement to dismiss counts 4, 5, and 6. You'd have no contact with any victims. The state agreed to recommend a specific sentence of 3 years fixed. However, they were free to, other than that, they were free to argue. You agreed to pay restitution, and this was a non-binding plea agreement. After I accepted the guilty plea in this matter, I ordered a pre-sentence investigation report be prepared. I have received that report and reviewed it. A copy of it should also have been provided to your attorney. So let me first ask Mr. Stillman, have you had a chance to review that pre-sentence investigation report?
Yes, Your Honor, I have.
All right, thank you. Mr. Gus Davis, are there any parts of that report that need to be clarified or corrected?
Not that need to be clarified or corrected, Your Honor.
Okay.
The defense does have an objection, though, to page 8. So I'll address that when the court's ready.
Okay. Let me take that objection at this point, Mr. Gus Davis.
Thank you, Your Honor. Your Honor, in that it has a kind of a short version of the evaluation that was ordered by the court, of the psychosexual evaluation. Looking through there, every one of those is a negative thing about Mr. Stillman. They're all things about him that are negative. There's no positive things. This is supposed to be, it's supposed to be an objective report of the good and the bad about Mr. Stillman throughout a throughout a PSI, so that we can address his risk. Your Honor is fully capable of reviewing the psychosexual evaluation, which was disclosed to the court and has been disclosed and has been attached to this to the pre-sentence investigation report. So I would ask the court to, rather than forming its opinion based on this shortened version, in which a PSI investigator tried to summarize the report of a doctorate level psychologist, I would just ask Your Honor to rely on his own review of this psychosexual evaluation during this proceeding. Thank you.
All right, thank you, Mr. Gus Davis. Mr. Muir, anything on that particular topic?
Well, Your Honor, I mean, pre-sentence investigations often contain information that is both, I guess, a positive and negative for the defendant. So that's not unusual. I don't think an investigator who has reviewed those reports and issues a summation is inappropriate. I don't believe it is inconsistent or in any way changes what's contained in Dr. Hatzenbuehler's report. I know that this court reviews all of those reports and is aware of what is in that psychosexual evaluation. So I don't, if this were something where it was contradicting that report, then, the objection may have more merit. I don't think that the objection really is, I don't agree with it. I'm opposed to it. I think what's contained in this report is consistent with what a pre-sentence investigator is supposed to do. So, I guess I disagree with the objection and would ask the court to deny that objection.
Well, it's not an objection other than to note that that is a synopsis. The court review doesn't see every one of those statements as negative, Mr. Gustavus. For example, let me go back to that page. For example, it says he acknowledged it's wrong to engage in sexual activity with an underage person or to force someone to engage in a sexual act. Certainly, I don't see that as negative. But the court also, just to be clear, the court reviews the pre-sentence investigation report, and I rarely rely on the pre-sentence investigator other than for kind of a general summation of perhaps the history of, the defendant, educational history, employment history, that type of information. I will, and don't think I've ever just solely relied on the pre-sentence investigator's assessment of assessments. So, but your opinion and objection is noted on there. The court will leave it as is, as being submitted. Mr. Stillman, do you wish to stand by the plea of guilty you previously entered in this case?
Yes, Your Honor.
Mr. Gustavus, are there going to be any witnesses on behalf of the defendant?
No, Your Honor. I just would note for Mr. Stillman, you have several family members that are watching in support of you. They can't be in the courtroom, so that's why it is being broadcast on YouTube.
Okay. Thank you, Mr. Gustavus. Appreciate you clarifying that. Mr. Amir, any witnesses on behalf of the state?
Just argument, Your Honor.
All right, then, Mr. Gustavus, pronounce sentence in this matter. I'll let you argue on your client's behalf. Thank
you, Your Honor. Timothy is 54 years old. He is single with no children. He has previously been married twice. I believe one of those had the woman had children of her own. However, there were no children born of any of his marriages there. He held employment for a long time. He worked for 25 years for Winco Foods here in Idaho Falls. He lived for several years in the same home. He paid all his bills, maintained his payments for his housing and such. He has suffered from mental health issues for quite a while, and they date back to probably in his maybe in his teens there, just from the development part of it. He graduated from high school. He has a high school education. It does not indicate that he was in any special education classes, and through evaluation that was done for him for the purposes of sentencing, he does not indicate any disability, but he does appear to be a slow learner, and he additionally family member that was interviewed pre-sentence investigation did indicate that he seemed to be a little bit slow. So Timothy takes a while to do some of these things. In discussion with the psychosexual evaluator, she did have to take extra time with Mr. Stillman to go through a lot of the parts of the report because he didn't understand them. Now, through the mental health evaluations, he does have a nonverbal learning disorder, which reflects his inability to grasp artistic concepts. He is a very concrete thinker, and that is reflected by Dr. Hatzenbuehler's report in the late 30s. I didn't mark it, but she says that he's a concrete thinker, but he has a hard time try to expound upon nebulous issues. He doesn't do well with that. Now, additionally, in the mental health evaluation, he was diagnosed by Dr. Landers as having an avoidant personality disorder. Now, I had to look that up to see exactly what an avoidant personality disorder is. And I'm not trying to testify as an expert or anything. I just want to give an example of what an avoidance personality disorder is and how that applies to Mr. Stillman as a person. It is a pattern of behavior that keeps a person from complying with cultural norms because they have feelings of nervousness and fear, chronic feelings of inadequacy, and being highly sensitive to being negatively judged by others. And they tend to avoid social interaction due to the intense fear of being rejected by others and for being shamed or ridiculed because they don't fit in. Now, this very much applies to how Mr. Stillman has lived. For the past 25 years, he has worked for Winco Foods. He goes to work and then he goes home. He has few friends. He interacts with family sparingly. He doesn't have a lot of the outside world. He lives solo. He is somewhat of a hermit, I guess is how I would put that. But additionally, because of the fear of rejection that he has with his avoidant disorder, he is a people pleaser. He wants to keep people happy because he fears criticism and rejection. He tends to reach out for whatever type of interaction that he can, and through the internet is an easy way to do that because the internet is faceless. You are not dealing face to face with a person. He has been undergoing treatment with Travis Dean here in Idaho Falls for approximately 7 years, going twice a week for the diagnosed depression and anxiety that he has. He has been diagnosed with severe depressive disorder, which has put him in State Hospital South a couple of times and Behavioral Health Center a couple of times. And over those periods of time, his stays have been lengthy because he has had suicidal behavior due to that depression. So those two things work against him there. He has developed an addiction to porn that being exposed to porn at an earlier age has now triggered this illegal behavior in his later ages. Evidently, according to the evaluation that was done, the earlier use of porn that he had was within the legal bounds. He has few leisure activities, which gives him a lot of free time and not much to fill that free time. When the police officers came to interview him, he willingly complied. He fessed up to what he had been doing. He told them it was beyond his behavior. He wanted to please them because that's how he is. So now, during the evaluation, he failed a polygraph. Most of the answers were both of the aspects of the polygraph were inconclusive. There were some answers that did not have reactions, but overall, because there are some reactions, the entire polygraph is inconclusive. Given his anxiety levels and his levels of avoidance and fear of rejection, I can understand why he could not pass a polygraph. Additionally, due to his avoidance and people pleasing, he would be probably subject to some victimization if incarcerated, Your Honor. I think that has to be taken into account. He has been in custody for 8 months. That for the court's purposes, that's a significant punishment and a deterrent, as well as that has been costly to him in losing housing, personal belongings, vehicle, job, etc. That has imbalanced that level of stability. Now, referring to the evaluation by Dr. Hatzenbuehler, in the PSI on page 10, Mr. Stillman wrote in there that I am sorry for what I did, and I know it was wrong. I shouldn't have done it, and I take full responsibility for what I did. I do regret what I did. I know that I do need programming, and I do need to be held accountable for my actions and to not do this again when I do get out. The rest of the statements in that statement are all summarized for him. And I want to point that out because in the evaluation with Dr. Hatzenbuehler, she did state that he tended to minimize his behaviors and minimize the risks that those pose. But he does understand that that is against the law and he cannot do that, Your Honor. And so he has a responsibility there, and he's taken that. Now, there were several tools that Dr. Hatzenbuehler used in the evaluation. The stable 2007 placed him in a moderate risk for use of pornographic materials in the future, but a low risk when considering a hands-on offense. And additionally, she made a statement in there based on her personal interactions with him. He does not appear to be a risk to children, does not appear to ever have caused physical harm. The fact that he's so non-social, I think, has to be factored into the fact that he is a low risk to commit offenses, as he is essentially avoidant of any personal interaction face to face. She did state, though, on page 32 that he does not believe that he needs treatment to address his impulses. Hence, he will be a challenging treatment client. He did take responsibility, Your Honor, in his statement to the court in the PSI, and he did state that he needs programming. So he does understand that, Your Honor. Now, for what should the court do with Mr. Stillman, knowing what we are dealing with here, Your Honor? Idaho Code 192521 sets forth that the court should consider placement in the community unless the other things are overweighed, the factors override that. So there is a preference for community placement if he is amenable to that. To protect society and rehabilitation and deterrence. So I point that out because he's been in jail for 8 months now, Your Honor, and he understands what he did was wrong. He is amenable for treatment. He shows that he can go to treatment because he has been doing that with Mr. Dean for 7 years, twice a week. So he can do the sex offender SOMB treatment in the community. We have several providers. He shows that he can be compliant with stability. He's had a job for 25 years. He's had housing for several years just in his last location. So the only real thing there is punishment and retribution. Does punishment require him to be put into prison, Your Honor? And I think that the court needs to consider, is he a risk to the community? And would placing him in the prison be a victimization that would be more punitive than the fact that he would be in the prison? So I would ask the court to consider placing him on probation for a considerable amount of time. There are restrictions that probation can do that would prevent him from accessing devices and pornography. Should the court not consider that to be appropriate, I would ask the court to consider retained jurisdiction. They can do sex offender treatment in a retained jurisdiction. He obviously needs the treatment and he recognizes he needs the treatment. So I would ask the court to consider that. For an underlying sentence, I would ask the court to consider an underlying sentence of 2 years fixed plus 3 years indeterminate for each of the 3 counts to run concurrently. Thank you, Your Honor.
Thank you, Mr. Gus Davis. Mr. Muir, can I have the state's recommendations?
Yes, Your Honor. Your Honor, the defendant appears in front of the court, frankly, on a very serious matter, something that the state takes very seriously. This case began with an investigation by the Internet Child Against the ICAC Department, Internet Crimes Against Children Department. The defendant, as indicated, is 55 54 years old. He began using social media to contact underage girls. This was accomplished by the defendant setting up a fictitious profile in which he identified himself as a person named TJ, and that he was 19 years old. He was contacted by law enforcement at his places of employment. They were discussing with him why he was doing this and the reasons why he would be contacting underage girls. As the interview progressed, law enforcement quickly began to uncover that there was much more serious criminal behavior going on. Law enforcement learned that the defendant had accessed pornography online, particularly pornography involving children. The defendant admitted during his interview that most of the pornography that he looks at involves children. The defendant went on to admit that he is addicted to pornography and to sex, and that he cannot stop viewing that and engaging in that sort of criminal behavior. Law enforcement did recover a laptop as well as a cell phone. They did a search of those, and on there they found that the defendant had more than 4,000 images of child pornography with ages of those children going as low as 3 years of age up to 18 years of age. I think it's significant to point out that the defendant was caught doing this, that he did not stop, and that he only came clean to law enforcement as soon as they basically had an overwhelming amount of evidence and contacted him at his place of employment. So this is a particularly serious crime, Your Honor, one that I think warrants a significant amount of punishment. As part of this case, the defendant obtained a psychosexual evaluation as well as a polygraph evaluation. I think some things that stood out to the state as we reviewed those documents is that during his interview with Dr. Hatzenbuehler, so during that evaluation process, the defendant was highly defensive. He was minimizing his offending behavior, which is very concerning to the state, that still minimizing what he was engaging in, despite acknowledging that he knows that it is wrong. She also indicated that the defendant was lacking insight into his sexual problems. And I don't think any of those bode well for an individual who is asking this court to be placed on probation. And the report also included a statement from the defendant that he does not believe that he is in need of treatment. I know that he has since changed that sentiment and has expressed to this court that he does need treatment. I believe, though, that his true intentions are bode out in that evaluation that he conducted with Dr. Hatzenbuehler. The polygraph examination, Your Honor, is obviously a tool that the court uses to basically to assess risk. I think obviously what was concerning in that polygraph examination is that when he was asked the question about having sexual touch any juveniles, he answered no to that question, and it indicated a significant reaction. So the defendant did not give a clean polygraph, which is concerning to the state. Obviously, these crimes are very, very serious as they deal with the exploitation and abuse of children. People like the defendant who possess this create a market for those individuals who are producing this type of material. These children are helpless. They are victims, and Mr. Stillman is contributing to that criminal enterprise. So, Your Honor, pursuant to the plea agreement, we are recommending a sentence of 3 years fixed and 7 years indeterminate for 10 years. We are recommending that for each count that he has pled guilty to. We are recommending that those sentences run concurrently so that the court and the court can certainly consider that as mitigation. That is certainly accounts for any mitigation that may exist in this case. We are not recommending that this court suspend that sentence and place the defendant on probation. We think a sentence less serious than his time being imposed depreciates, obviously, the seriousness of this type of crime. And so we are recommending that this court impose that time. Certainly, any sort of treatment can be conducted while in custody, so that those opportunities will not be deprived of the defendant if the court does, in fact, impose his sentence. And so he will certainly have an opportunity to engage in that treatment and show the parole board, if that time comes, that he is then safe to put out in society. But we think certainly these types of crime implicate community safety. I would note that the individuals that he was contacting in this cases were juvenile females. And so with that, Your Honor, we think that that is the appropriate sentence in this case, and that would be our recommendation. Thank you.
All right, Mr. Stillman, before I announce sentence in this matter, I will give you a chance to address the court. You are not required to say anything, nor do I hold it against you in any way if you choose not to. However, if you do wish to exercise your right of allocution or your right to address the court, I would give you that chance, sir. Is there anything you'd like to say to the court?
Yes, Your Honor. I just want to say that I am sorry for what I did, and I do express remorse for that, and I do want to get treatment and get help for what I've done, and I just acknowledge what I did, and I don't plan on doing it again for sure. That's all, Your Honor.
All right, thank you, sir. Are you satisfied with the representation of your attorney?
Yes, Your Honor, I am.
Mr. Gustavus, is there any legal reason why you should not sentence the defendant today?
No, Your Honor.
And Mr. Stillman, based upon your pleas of guilty, it is judgment of this court that you are guilty of 3 counts of child sexually exploited material, willfully possessing or accessing by any means, as contained in the prosecuting attorney's information. I have carefully viewed the pre-sentence investigation report along with the attachments in this matter. I have listened to the argument of your counsel, as well as the argument of the state, and also listened carefully to your statement. The court also has the obligation of considering this sentence in light of the objectives of criminal sentencing adopted by the Idaho Supreme Court. Those are the protection of society, deterrence, rehabilitation, and punishment. The court also has a criteria, as cited by Mr. Gustavus, to consider the criteria set forth in our Code 1925-21 relative to the question of whether I should place you on probation or confine you to prison. In reviewing this case, there are certainly some mitigating factors. There are aggravating factors, however, as well, Mr. Stillman. Of course, can address both of those in considering the sentence. First and foremost, I just want to refer to some of the official version on page 1 of the pre-sentence investigation report, where it talks about how you use that fake Facebook account under the name of TJ, telling girls that you were 19 years old. The picture was of a young guy playing the guitar. You talked about how the younger girls were more outgoing and chattier, and that you were lonely and wanted to talk. However, the problem with that then is Mr. Stillman admitted asking the girls if they were virgins. He also admitted to making phone calls with them. So it certainly went beyond just chatting, but if you're starting to talk about sexual things, that's extremely concerning to the court. Now, the number of pornographic websites and the images that were discovered were in the 4,000 range. And it says the age of the children were from approximately 3 years of age to 18 years of age. Now, your version, and frankly, Mr. Stillman, I find this to your credit, it says, you described the crime as, I was accessing pictures and images that were pornographic and child sexually exploitive. My addiction to pornography had progressed, and I started doing different material and saving it on my computer. And I think that that says a number of things. One, that it's an addiction, you recognize that, and that addiction was getting worse. Your counsel talked about how that you had access pornography, but it was legal, and then it exceeded those bounds then when you began to access those child pornography images. Now, Mr. Stillman, I was impressed by the fact that you had the same job for 25 years, that you had worked at Winco for 25 years. Also, the fact that you had sought out treatment of a psychological nature. You had been meeting and had been receiving prescription medication, and now are currently still receiving mental health treatment. The court has reviewed the psychosexual. I wanted to refer to page 31 of the psychosexual, where it talks about kind of a summary, the forensic opinion and recommendations. There it talks about the fact, this is in the middle of the first paragraph, is there appears to be a relationship between mental health issues and his sexually offending. He is socially anxious, so let's talk about you, Mr. Stillman. He's socially anxious, and internet conversations with both adults and young teens have provided him with social activities while allowing him to avoid the stress of personal contacts with real people. That being said, he does appear to use pornography and masturbation as stress relievers, and he admits that he has found images of prepubescent females arousing. So that goes along with what you yourself indicated, that your addiction was getting worse. And the court, in looking at this, finds that you had taken the next step, looked like you then had reached out to underage girls intentionally with the intent of at least engaging them in conversation, first online with a fake Facebook account, and then later with phone calls. On the third paragraph down, still on page 31 of the psychosexual, it talks about despite the defensive manner, so it talked about your defensive matter, and I do think that's tied into the mental health issues as well. You still completed the part of this evaluation. Mr. Stillman meets criteria for the following DSM diagnoses: major depressive disorder, reoccurrent severe without psychotic features, generalized anxiety disorder, and avoidant personality disorder. The counsel talked about what that means as well. In the next paragraph, to your credit, it says you do not have a significant criminal history. However, you did admit to the arousal to prepubescent females. There is, this is from the third line up from the bottom on page 31. He does not appear to be a risk to young children and does not appear to have ever caused physical harm to a victim. Now, the state argued about the psychological harm and the harm that the victims that are being portrayed in those pictures encounter. However, in looking at this, I do think that the addiction was getting worse. So when I look at this and I look at the goals of criminal sentencing, that of protection of society, deterrence, and rehabilitation, the court has the obligation of looking at those and considering what to do in light of that. On page 11 of the psychosexual evaluation, and this does have, like I said, the court does not rely on the pre-sentence investigator for a psychosexual evaluation analysis, but the last paragraph, their summary, the court does consider that. It says, I believe the defendant will have challenges in fully complying with the terms of supervision. His lack of insight done by his actions, combined with his lack of motivation to sex offender treatment and mental health issues, are highly concerning. Ultimately, there's a recommendation for incarceration. You have talked about today how you think you need treatment, and I think that's good. That shows progress on your part. So considering all of this and considering the different criteria, it's going to be the judgment of this court. You should be sentenced to the custody of the Idaho Department of Corrections as follows. On each count for a minimum term of 2 years, followed by an indeterminate term of 8 years for a total of 10 years. I'm going to order those sentences run concurrent with each other. I'm going to order a fine on count 1 of $1,000. Will not order a fine on counts 2 and 3. I'm going to order standard court costs, payments into the Victims Relief Fund, reimbursement to the county for both the public defender services in the amount of $500, as well as for the cost of the psychosexual evaluation. That's why I did not order a fine on the other 2 counts. I am going to order that you register as a sex offender pursuant to Idaho Code 1880-307 upon your release. I will give you credit for the time that you've served so far on this case. And what that tells the court is that there are treatment programs in the Department of Corrections, an 18-month program, and hopefully you can take advantage of that and begin that treatment prior to going before the parole board. I remind you, sir, you have the right to appeal to the Idaho Supreme Court from this judgment of conviction. You have a right to represent a binding attorney in that appeal. If you cannot afford one will be appointed for you at public expense. However, you only have 42 days from today's date to do that. You also may have rights under Idaho Criminal Rule 35 if you feel the sentence was illegal or unduly harsh. You have 120 days for that. You also may have rights under the Idaho Uniform Post-Conviction Relief Act. Such an action must be filed within 1 year from the date that your right to appeal expires. Mr. Stillman, I hope you can get some treatment. I do think you've made some progress. I think that needs to continue. I certainly would encourage both mental health treatment as well as sex offender treatment. Anything further on this case, Mr. Gustavus?
No, Your Honor. Thank you.
Mr. Muir?
No, Your Honor.
All right. Good luck, Mr. Stillman. We'll be in recess on this matter.
Thank you.
Thank you, sir.